Hello and welcome back to 2024 with Morris Succession Lawyers. Just thought I'd check in, say hello. It's been a little while since our last video, but now getting back into the swing of it with the new year. I just thought I'd take the time to also talk about the way property ownership works and how that interplays with estate planning. So obviously there's a lot of different ways that you can own property. You can obviously in a personal name, but for couples in particular, you can have a joint ownership where basically if one of them passed away, it automatically reverts to the survivor. That's commonly used by most couples when purchasing property. You can also have a tenants-in-common arrangement. That's where one party owns 50%. You might have another party that owns a separate 50%, but that can actually be in any particular fractions. You can have 9% owned by one party, 1% owned by another party. And the difference between a joint ownership and a tenants-in-common arrangement is that mainly on death. So for a joint ownership on death, it automatically passes over to the survivor. But when you have a tenants-in-common situation, then the person's will or the rules of intestacy apply to that particular portion. So if a husband and wife own 50-50, then the husband passed away, his will dictates what happens to that 50%. So in an estate planning sense, it's really important, obviously, for us to know how properties are structured, whether there's companies or trusts involved. Sometimes on the face of it, it might look relatively simple. I have clients today who own property, one portion's owned jointly together, just in a regular personal capacity, and another portion of the property is owned jointly, but as trustees for a self-managed super fund. So little things like that, if you just looked at the title, it might look like they just own it together. But in actual fact, there's a distinction in the ownership that have major implications upon death. So if one party was to pass away, then yes, the part that was jointly owned together would just pass between automatically to the survivor. But the portion that's owned by the self-managed super fund, yes, the trustees would update, but that may trigger the forced sale of the property to pay out the death benefits for that particular person from their self-managed super fund. It's really important for us to know exactly how things are owned. That's why we would typically involve people's accountants, or sometimes I have clients who have their own conveyancer. We'll talk to and liaise with the conveyancer, because sometimes you need to look at the front page of the contract to find out how a property was owned. And how those property ownerships are affected by death also dictates then how we draw up an estate plan. It's not uncommon for us to deal with clients who, first of all, might be freshly separated from a partner or having just gone through a divorce. In that situation, we will want to change that ownership if it's joint to sever it and create the 50-50 ownership, at least while a property settlement's being sorted out. That's just to avoid the scenario of the automatic passing of the property from one partner to the other. So that can be like a temporary measure that we would put into place. The other occasion where we sometimes change ownership, you might go the other way. We might have people who have purchased property as a 50-50 type situation, but that in itself, because the property passes via the will, you have to then go and get probate to be able to pass that property on to the other person, if they want to gift that, of course, to the other party who owns it. So you can change that to change it joint. The other situation is you might have had, we might be dealing with people where one party to the relationship already owned a property when they met, or sometimes for asset protection purposes. I deal with a lot of doctors. They might typically have their partner owns the property, and they avoid having assets in their personal name, mainly for asset protection. Of course, when they retire, the asset protection needs may go away, and there's actually a stamp duty exemption in New South Wales to take a property, as long as it's your home, your principal place of residence. Then if you're married or in a de facto relationship, there's a stamp duty exemption to put the property into joint names or 50-50 from one person's name. Sometimes we would do that. The other situation where we play around with titles and where titles are really important is blended families. With blended families, we often go the other way. They might have a joint property that people have purchased together, but because it's an automatic passing of that interest in the property to the surviving partner, that's a bit of a blunt tool. It doesn't really give us any flexibility from an estate planning perspective to play around with how that ownership is passed. Now, in every other state in Australia, that may be a desirable thing because they don't have this New South Wales concept of notional estate. So in New South Wales, if you've got a blended family, say mum's had 2 kids from a previous relationship, dad's had 2 kids from a previous relationship, those children may not have a claim on their step-parents' estate if they're left out of their will. Now, what that can cause is if property is passing to the surviving spouse, those stepchildren may not have any comfort that they'll be left anything from the step-parent down the track. With people living so long, sometimes you might have a party to relationship outliving the other by 20 or 30 years plus. And in that time, relationships can fracture and the people can have somewhat of a distancing, not necessarily a falling out, but just more of a distanced relationship where they may not feel the same connection that they might have had when both parties to the relationship were alive. So without that comfort of knowing that they're secured, that something might come from their parents' estate, those stepchildren may choose to bring a claim against their stepmother or father, and they've only got 12 months to make a decision. And the pressure of that timetable can really force litigation. So that's where having more options available for a blended family and having a tenants-in-common situation where we can use a trust or we can use a right of residence, it definitely can help mitigate some of that litigation risk. So having that flexibility definitely plays into an estate planning perspective, but it needs to be looked at as a whole. What may reduce a litigation risk often may lead to tax consequences or land tax in particular. If you've got a discretionary trust owning 50% of property, discretionary trusts in New South Wales don't get any benefit of any threshold for land tax, so they pay land tax from the first dollar. So there'll be a land tax implication. The other implication in deploying trusts is that you're going to have that ongoing relationship required between the surviving spouse and some party acting in the interests of the children of the first person who's deceased. All of these issues, as well as mainly with super, there's some other tax consequences as well when you start dealing with blended families. What may fit from a litigation risk perspective doesn't work from an accounting perspective. So it's really important that you have a holistic approach where the financial planners, the accountants, the conveyancers, everyone's working together to get the best result for their clients. So property ownership's a major part of estate planning and getting a good grounding in terms of where a client's assets lie. So sometimes people can wonder why you need to ask these questions, why sometimes we might want to do title searches and maybe even get some records from the conveyancer about when the properties were purchased. These are the reasons why we need to do that, because you just can't simply do your job properly unless we have the information. So that's it for today. As always, if you've got any estate planning queries or estate litigation, deceased estate administration, then feel free to contact myself and the team at Morris Succession Lawyers. And you can find us at www.mslaw.com.au or give us a call on 026584 1185. Hope everyone's had a great start to the new year, and it's certainly looking like it's going to be a busy one for us. So stay tuned.